Welcome to the Elephant TV. My name is Abdullahi and our guest today is Dr. Hussein. Dr. Hussein, welcome to the Elephant TV.
It's great to be with you.
Today we'll be talking about the community land laws and how it impacts the people of Northern Kenya. Dr. Hussein, I wanted to start with, more than 65% of Kenyan land mass is estimated to be community land. Such land is occupied and used primarily by the pastoralist communities in Northern Kenya's Dryland. How does Community Land Act address this issue?
I think to start with, I think it's good to look at the historical perspectives of how legal frameworks around land, especially the pastoralist occupied lands, have developed over the years. If you look at from the time of the colonial period up to even the larger part of the Kenya's independent government, pastoralist inhabited lands were basically managed through some peripheral legal systems. It was never at the center of Kenya's land legal frameworks. For example, the main management tool was the Trust Land Act from 1939, revised I think a number of times, and this basically meant that the land of course belonged to the people but managed on their behalf by the government of the day, and the government managed this land through elected leadership councillors of the time, who more often at that time they were either semi-literates or illiterates, and they did not understand even what it meant to manage land at that scale. And of course it was seen that there was a lot of misappropriation of land was being taken away at whim for any other purpose without really due consideration of the pastoral production system. But later on, again, looking at the issues that has affected the land, there came up a law that was called the Group Representative Act of 1968. And this looked at, how can communities register land? And this one also, it was not looking at how pastoralists can manage land, but how through privatization or semi-privatization of land, management was to be improved. Because this borrows now from the fact that people say that, pastoralists don't manage their land. It's just, everybody puts in as much as livestock as they want. So they were moving towards how do we privatize somehow to improve management. And that was through now bringing in families and clans to own land. This was mainly accepted by people in southern rangeland, especially the Maasai and part of the Samburu. But the people around the northeastern and even the larger areas of Turkana, for example, northwest, never accepted this, and their land remained under the Trust Land Act. And the misappropriation continued. Now, this land, of course, and also generally land in Kenya, was under a lot of focus, especially due to conflicts and irregularities of land allocation. There was a lot of issues with land that brought upheavals in the country. And so because of this, there was a lot of review of land laws, and then that is when also these communal or land areas also came under focus. And that is how through the National Land Policy of 2009 and later on the change in the constitution, then these laws now were put in place with specific focus now on how to improve ownership and management of community land. So if you look at this law per se, it centers on three things. It just basically looks at how can the ownership of land by communities be recognized, how can it be protected, and how can it be registered. So that is the essence of this law. And if you look at it, then the important bit of it now from your question is, now it provides form of ownership, and the ownership by community themselves. And beyond ownership, it also creates structures, management structures by the community themselves to be able to sustainably manage the land. However, if you look at the progress, and it's now, the law came into force 2016, it's now going to almost 6 years down the line. Implementation is still dismal, and I will say only communities that were able to register as group ranches converted, and this was just basically changing, some few elements around to convert, while the larger trust lands, no community up to now has been able to register. And of course, if we continue our conversation, we can see why some of this is also happening.
Thank you, Dr. Hussein. I think tied to the history that you gave, there is always the question that there is this notion that there is free land in northern Kenya. As a result, we've seen the scramble for land, whether to set up large-scale infrastructure by the government, wildlife conservancies, and even Kenya Defense Forces acquiring hundreds of acres. How does this affect pastoralism when you consider that pastoralism relies on unimpeded movements in search for water and pasture depending on the season?
Up to now, actually, the Kenyan government has not fully appreciated the value of this land. It has never valued, the billions that is generated from production of livestock. It has never looked at other, natural resources that are there. It's only recently now that they are realizing that this land is of some use, but otherwise it has been considered wastelands. And when you talk about this conversion of land, it's basically for others. It's putting the land to better use. It's land that has not been seen to be used. So the conversion to us, which we think affects pastoralists and their production system, for others is putting it into better production. And this kind of thinking actually is supported by existing laws, and there is a certain law, the Land Valuation Index bill, that revised some of the laws, and just as late as 2019, still carries this notion. It doesn't give any value to pastoralist land. It actually, use the classical way. It looks at, is this land, is there any infrastructure on this land? Is it being agriculturally used? So if any of this is not there and it's not been registered as a public land, then that is regarded as land which does not have value. And for even this major investment now that has been attracted to the region, nobody is looking at the value of this land. A case in point, for example, is just close to us here is the Lake Turkana wind power, which generates, close to 7 billion shillings a year. And that is on 100 and actually 4,000 acres of land. And that is the value that this land, can have. But up to now, even how that land was allocated to the wind farm is contentious. So there's that thinking that still stays with us, that these lands are wasteland and conversion happens. But when this conversion happens, little consideration is given as to who has what rights and who has been producing on this land. So the impediments that come up, these lands, if you look at how pastoralists view these lands, pastoralists classify land in different ways, and they know what resources are in there. They know where to fatten their livestock, at a given time. They know where to go when, the dry season gets so intense. And sometimes, and also the other thinking is, they look at the land. A lot of people from outside just look at the vastness of this land and say, we're only taking out a small bit of the land, and it doesn't mean anything, to this production system. But if you look at the intricacies of how this land is viewed and used by the pastoralists themselves, it can be detrimental just by taking a small section of, for example, critical resource. It can make the whole system to collapse. A good example, for example, is Isiolo, the Waso Basin, for example. There's some infrastructure development, what's called the Crocodile Jaw Dam, being proposed. And a lot of times people assume that the land just, the dam will basically control flooding and there will be water flowing for pastoralists. But the vast land that is served by the floods, which is the lifeline, actually not only for the Isiolo people, but pastoralists from even Wajir, Garissa, Moyale here, it's never considered. So Abdul, that look where people look at, just a small portion of the land and not looking at the interconnected resource that this land is a major impediment. Even as this law is being implemented, we continue to face these challenges of this land still being viewed as wastelands.
Thank you. I think that there's something there I would want you to, go into a little bit of details. It's the question of just and fair compensation, right? Whenever government takes over the land, compulsory, the law, at least says that there has to be just and fair compensation. But in pastoral areas, because the region has not developed very well, the community gets, the short end of the stick. Do you want to give a little bit of insight into, how just and fair, compensation doctrine is hardly applied in the pastoral areas?
In our laws, as you've put it, yes, one's land is acquired, for various purposes. It can be for public good, it can be for security purposes that serves, again, the larger public. There's a mechanism that has been put in place by the government that the land can be acquired, even despite, other preceding uses that are there. But as you've rightly put also, it has to be acquired according to the law, and there should be just and fair compensation that happens. And it's even stated within the Community Land Act that if pastoralist land, even as it were unregistered, if it's even unregistered community lands are acquired, it's supposed to be compensated the same way, valued and compensated the same way. And it gives actually a framework where because the land is under trust, it's held in trust again by the county government before it's being registered. It actually clearly states that even the county governments, when they receive compensation for this, it has to put these monies in an interest earning account until when communities are registered and be able, to receive the value for the land, including the interest that this monies have accrued over the years. For the time that they were not able to claim. But if you look at it now, how things are done, contrary to the law, and of course, one impediment is, and again, the contradiction within the law itself. I just mentioned that the land value index, on the other hand, doesn't give any value to this land that this law says has to be compensated when acquired. But again, we have a challenge within our own also kind of system. What we see is that the land, for example, an unregistered community land is under trust of the county governments. Here, the county governments, sometimes we've seen where they think that they are the owners of the land because they say they are the representative of the community itself, and they can make decisions of land acquisition on behalf of the community, which is kind of, unfortunately, it's a misconception that prevails. So what happens is a few leaders are consulted and they assent to land acquisition on behalf of the community without any compensation. And many a times, because also our people are here to know what legally, their rights are, they're just given some small tokens here and there in terms of corporate social responsibility. And that is what they think is the value of their land. And that is not actually. So, Abdul, what we could say is that there is a lot of happenings contrary even to our own laws, that land are acquired and nobody consults, the owners of the land, and no compensation is provided. But fortunately, some precedents are being set, like, for example, the electrical wind power that I also just mentioned. The case was in court for many years, but finally the verdict came out and said that the acquisition was illegal, although still how that is corrected and community gets compensation is a different story. But it's a precedent in itself that then teaches the community that their land, they can go to court and get fair hearing and be able to get redress through the legal system.
Thank you, Hussein. I think one of the things that I really would want you to explain or help us in understand is the question of Indigenous land management system. You've touched on it. I think within the Borana community, there is the EDA system. Within the Turkana community, there is Equar. How has this been incorporated into the land management system, or it hasn't, particularly by the county administration? How can this indigenous mechanism be used in taking care of the land? In terms of the use of the land, the good thing is with the Community Land Act, it gives the community, it vests ownership. That's what it actually says. It's a vest ownership and management of the land to the communities themselves. Actually, they do much of planning and use of the land, but then they only, do this in collaboration with the government. The only caveat is that they have to manage the land, in an equitable, productive, and sustainable manner. If they don't do that, the government can take away the land. But now, again, further now to your question, the good thing is
the community within this Community Land Act has a leeway, of coming up with what is called bylaws, to manage the resources that is on the land. And a lot of communities that we have interacted with fall back now onto their own traditional systems of governance to draft bylaws. For example, for water, there's quite detailed, laws. For example, the data that you have just mentioned has very detailed laws around even use of water itself. What the types of water sources, the management system, what happens to somebody who breaches, these rules, and all this now can be written down in form of a bylaw, and it's actually one of the documents that is presented, during the registration of community land. And upon review by, the community land registrar, and if he or she finds that whatever is put there is not contrary to any of the Kenyan laws or the constitution, and if it is accepted as one of the registration documents, then it becomes a document that is sort of legally binding, and it will help the community. And this is one of the challenge. This is one of the challenge that has been there with our traditional system, because there's no law, or legal frameworks within our country that recognizes this informal resource management system. The rules have been there. When they try to impose, others will say, take me to the police, take me to the courts if you wish, and it reaches a certain level where they are unable to do that. But now, if they are able to register their land under the Community Land Act, and if their bylaws are accepted under that, then they have support now, a legal document that can support enforcement of access and use rights of their resources. And interestingly also, with the pastoralist resource use, as I've said, the interconnected nature of resource is quite important. And some of these critical resources that are at a certain point are depended on by communities that are further away from this, through mobility they have always accessed. And the good thing with this law is that it provides also for a provision where not only the ownership, but the use right of such individuals for seasonal use is also documented and guaranteed. And then what we call nested, use of the land is still allowed. It's not like a private plot where you say nobody else can access except, myself, who is the owner. Their claims, there are window of claims that are allowed for user rights claims by others who have seasonal use rights on this land. And looking at this, then the Community Land Act actually provides for how the communities can use their own existing informal governance systems to strengthen management and sustainable use of their resources.
Thank you so much, Dr. Hussein. That's really fascinating. I'm sure we'll come back to you at some point regarding the land question. Thank you once again.
You're most welcome.